Greetings. This is Attorney Welch again, talking more about criminal evidence. This is the second recording in that area. To now look at some questions to apply knowledge of criminal evidence. The first question: a police officer can arrest a person without a warrant when he has reasonable grounds to believe that a felony has been committed and that the person before him committed it. And that is true, and that is the definition of probable cause when an arrest can be made without a warrant. Another situation in question 2, for an arrest under the Terry case, called the Terry stop, it is not enough to state someone was in a crime-filled area. That's true. You need some reasonable suspicion. Question 3, an alleged murder weapon is an example of real evidence, R-E-A-L. Question 4, an attorney may ask leading questions on cross-examination of an opposing witness, and that is true. You may not ask leading questions of your own witnesses because they're supposed to testify freely. But cross-examination of an opposing witness is very, very powerful. That's the great engine of the law, cross-examination. Isn't it true you're in love with the plaintiff? Isn't it true you'd say anything for them to win? It's like you're testifying and they simply answer yes or no. Next, the primary methods of impeachment are as follows: contradictions, showing they said one thing at one time and one thing on another occasion; prior inconsistent statements; bias or interest, maybe they're a family member or a friend; sensory deficiencies, such as they cannot see well, they could not have heard well, they could not have used their senses to perceive that situation. In 12 Angry Men, that is a show that showed examples of witnesses being impeached because of sensory deficiencies. One would be their reputation, or another one would be their opinion for untruthfulness, prior acts or misconduct, and prior criminal convictions. You have to look at your statute in each state. For example, some states say if it's a felony and it's committed within the last 6 years, you may be able to use the felony for impeachment. But each state is different in that area. In a criminal prosecution, the accused shall enjoy the right to be confronted with the witnesses against him. Yes, that's by the Constitution, that they do have the right to confront the witnesses against them. A witness is a person who gives evidence and is able to be cross-examined. That's true. That's a very good definition of what a witness is. Next, direct evidence requires the trier of fact to believe the evidence or to believe in the credibility of the witness. And that is true. That is opposed to circumstantial evidence, which requires the trier of fact to draw rational inferences in order to find the fact for which the evidence is offered. That's true. Circumstantial evidence requires the inference. To provide testimony under oath, the witness who is under oath must relate facts within his personal knowledge. That is true. A lay witness must have personal knowledge of what they are testifying about. Next, two broad categories of evidence are testimony under oath and documents. and that is true. An attorney may not ask leading questions of his own witness on direct examination. That is true. A witness must testify freely. This will be the end of our second recording concerning the important topic of criminal evidence. Stay tuned for tape recording number